Good morning, folks. This is Andy Stautz at Stautz Law. I'm an Indiana estate planning and probate attorney, and today I am here to talk about DIY wills and how they fail. And this talk is prompted by my recent experience. I've had several estates in the past few weeks where there have been complications, expensive and unforeseen complications arising from a decedent who left a DIY will, right? So these are people who thought, oh yeah, well, you know, I can write a will, I can do it myself, okay? And they fail in all sorts of different ways, but there are a few that are the most common. So let's start at the start. Can you write your own will? Yes, you can. Obviously, and there are now lots of websites online where you can download a will. It's an option, it's out there. But there are some traps, and I think it's worth paying a professional to do for you, to make sure you don't fall into one of these traps. So what am I seeing? What do I see? Number one, most obvious, is the will was never witnessed. Okay, so if you just write on a piece of paper, the house goes to Jerry, and you sign it, that's great. Hopefully your heirs will honor that, but they don't have to. It's not a valid legal document. We can't present it to a court and say this is his last will and testament, because Indiana law requires two witnesses. Which brings me to the second obvious problem. A lot of times it'll be, I leave my house to Jerry, signed, Bob and Jerry. And it's like, you can't do that either, okay? A witness who's interested, the guy who gets stuff under the will can't be a witness to that bequest, okay? It doesn't necessarily invalidate the whole will, but Indiana law makes an interested witness invalid as to the bequest, as to the gift he gets. So giving the house to Jerry and signing by Jerry, that's no good. Okay? What are some other common problems? Those are probably the two most common. Vagueness is another common problem I see. It'll say, I leave in my car to Jim, and it's maybe that writing is dated years ago. It's like, okay, well, which car? What are we doing here? And it's a bigger problem for real property. I mean, a car, no big deal, but land records are more formal. The recorder has to accept the evidence that the transfer happens. So that's another problem. Finally, are things that aren't necessarily like fatal to the will, but are annoying to the heirs who have to administer it. And probably the most annoying is, no self-proving affidavit. So if you just sign the will with two witnesses, it's valid. But to get it admitted to probate, one or more of the witnesses has to come forward and swear that it's actually the will. You can avoid that, and all professional wills avoid that by adding a self-proving affidavit to the end, which is just some magic words. But what it does is it excuses you from having to bring the witness back at time of probate. So just a little trick. And finally, I've never seen a DIY will with an consent to unsupervised administration. But if you've got cooperative heirs, that little consent saves you like thousands of dollars in probate, because it lets you use the unsupervised procedure, which is so much faster, so much easier than supervised probate. So those are some common problems. There are more bizarre ones, but by far the most common is failing to properly execute it. and then the rest are subsidiary problems. So I think you should hire a professional if you're thinking about getting a will done. It's not that expensive. It'll save you lots of money in the long run. You know, eh, I don't care, I suppose, because a messy probate is more expensive, and that's usually in legal fees. So it's for your own good. Get a pro to look at it beforehand and save yourself trouble later. But that was just a quick talk about how these DIY wills go wrong, and hopefully give you something to think about. Thanks. Bye.